department. Here, all girls have a best view before the court on there. If the attendance and shall be heard.
Please be seated. First case for oral argument this morning is number 717, People versus Maston.
Good morning, Your Honors. May it please the Court, Leah Farwell for Appellant Monteith Maston. Unless the Court has any specific questions about the appeal waiver encompassing the assault charge, I will focus on point 2 of my brief, the ineffective assistance of counsel. So this is not a mere losing strategy, but escalating and pervasive errors that prejudiced Mr. Maston to such a degree that a new trial is warranted. Trial counsel made 3 compounding errors. First, counsel... I'm sorry.
Go ahead.
First, counsel opened the door to an inadmissible, prejudicial photograph by asking a question that he knew the detective...
But wasn't there a strategy there?
Your Honor, I don't think so.
His whole point was, this is not the person that did it, period, blah, 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 blah. And now you have something that's coming forward that maybe he was paid, right? So therefore, once it's out, that's a strategy. He should be introducing it instead of having the people introduce it.
Your Honor, I understand your question and I understand the argument. I disagree. When they were arguing over the photo to be, when defense counsel was arguing that it was prejudicial in the first place, he asserted that no one could testify about the murder for hire theory. He knew there was no proof whatsoever that this was a murder for hire. There was no one that could testify about any transfer of money.
No, there's no question that that's how it started. But then what he was trying to say is, aren't there other people that could be responsible for this? That's where the strategy came in. He was just trying to get from the officer that perhaps there was somebody else that could be responsible, and then he didn't know that this was what the witness was going to say, and that's how it started.
But, Your Honor, I think that is where the true ineffectiveness lies, is that he asked a question that he knew would lead back to this murder for hire theory, that he knew that the detective could not answer without calling upon hearsay evidence or that inadmissible prejudicial photograph.
Let me just follow up on that, too, because I'm not sure I'm with your argument. It seems to me that what the argument should be, if at all, is that defense counsel didn't say, Your Honor, I move to strike that non-responsive answer to my question. You haven't made that argument, but even then, when that happens during trial, the lawyer has 2 choices. So-called ride with it, as the justice presiding is referred to, that seems to have been the strategic decision, to ride with it. Let's go with this answer and try to impeach it, or move to strike it. But moving to strike such testimony after the jury's already heard it, sometimes people think is less effective than riding with it, so to speak. But isn't that decision in and of itself, between riding with it, to use my language,
That's right.
and moving to strike, isn't that in itself a strategy that counsel selected and wouldn't be the basis for ineffectiveness?
Your Honor, perhaps that was his strategy. However, it comes back to those compounding errors, because next he entered the photograph itself as the only defense exhibit at trial. And this was over the courts. The people make an argument that the photograph was inevitable, that if defense counsel didn't enter it, then the people would have. That is not what the record indicates. Both the district attorney and the court indicated that they would allow the people to show the witness the photograph.
That's what they did. That's what the judge said initially. However, thereafter, the judge said, yes, it would be admissible by the people.
Your Honor, I just don't recall that point of the transcript. However, I think that based on what the people requested and the court's language, they said, to me, it was for ID only. The third error was that counsel failed to request a limiting instruction on how the jury should apply or approach the photograph, whether they could apply it only to motive. there's no cognizable legal strategy here. Trial counsel himself stated that the photograph severely prejudiced Mr. Maston, asserted no one could testify about the murder for hire theory, and knowing all this information, he still asked the detective on the stand a question that he knew could not be answered.
But we don't know that for sure. But we will look at that very carefully.
All right, thank you very much, Your Honor. And if there is nothing further, I would rest on my papers. Thank you very much.
Mr. Punch?
Thank you, Your Honor. Defense counsel had this information that someone else put a hit on the victim a week prior to the murder. It would have been ineffective not to follow up on that in some way. The way he did was appropriate, trying to establish that this other person had the motive and not the defendant. He didn't know that the detective was going to answer the way that he did. And I think to Justice Kern's point, he has two choices to make at that point. He made what was a reasonable trial strategy in making that decision. Regarding the point about whether or not the judge was going to allow the photograph to be in evidence or not, the quote from the trial transcript is, "I'll allow the people to offer that exhibit," obviously. I would read that, and I did read that to say I'm going to allow them to admit the photograph into evidence. Even if that's not the case, and it's as defense counsel states, it's really not relevant. The photograph was already described, and it was established that it was posted to defendant's Facebook account. Defense counsel would have the same incentive to establish that it was tenuous to this defendant.
Well, Mr. Punch, allowing the photograph in then, I suppose, once you decide as counsel to ride with it, again, using my loose language, that once the defense counsel does that, having the photograph come in, the counsel can then use that to say, look, yeah, there's money in this photograph. Well, they don't know where he got the money from. They don't know anything about this money, and they can use that to support the idea that it's shoddy investigation with respect to the discovery or investigation of another person potentially that did the crime here. So we got to look at whether or not, once you're down that path of riding in it, maybe that's not ineffectiveness, but maybe the ineffectiveness is choosing not to move to strike. What do you think about that?
Your Honor, I don't think there would have been grounds to move to strike. What the question was, you didn't have any proof of that, and the police officer had to testify truthfully. He thought that this tenuous photo did constitute proof on that. But even if he could have successfully moved to strike, that's a strategic decision to make, whether or not, and he even said that's what he had to do. He decided that it would look bad in front of the jury if he did not continue or ride with it, as Your Honor said. And it doesn't constitute ineffective assistance of counsel that he did take that position.
Okay, thank you. Do you have anything further?
No, Your Honor. Thank you.
Thank you. 720, People versus Kenneth Tyson. Excuse me.
May it please the court, Michael Hillary appearing for the people. I'm asking this court to find that the extent of the delay in this case, which the trial court found to be 14 months, was not dispositive and was within the constitutional limitations for speedy trial.
What was the rationale for that delay?
There's actually a significant piece to that delay that went pretty much undealt with by the court, and that is that, and this is sort of a retrospective subtraction of time, but it nevertheless should have been a subtraction of time, and that is that the laboratory report in this case did not become available. The conclusions had not become available until May of 2022.
It wasn't submitted by anyone till then, right?
It did. The items of
Whose
clothing.
fault was that? Was that the defendant's fault that it wasn't submitted timely?
Well, no, no, that wasn't defendant's fault, but the state police submitted those items of clothing within 3 days of the incident to the laboratory. Within 3 days, the laboratory had it. And the laboratory...
In 22.
I'm sorry?
In 2022, right?
Yes, that's correct.
And this incident occurred when? 21?
And the incident happened December 25th of 2021. So by December 28th of 2021, the laboratory has the items to be tested. They do not generate the results or produce those results until May of 2022. Well,
That was after an expedited request, wasn't it?
yes, but that time should not have been charged to the people because the lab is not an arm of the prosecution. But the court did not subtract that time. The court said from the incident date to the time of the indictment, 14 months, was all chargeable to the people. Now, even if that were the case, that was not an extraordinary delay, given this court recognized in Jenkins, for instance, a 2003 decision.
Mr. Hillary, I wanted to talk to you about Jenkins, because I then used that to springboard into other cases from our court. And I came up with Williams from 2014. That was a 14-month delay. That was acceptable. I came up with Polvino from 2014. That was a 21-month delay. That was acceptable. I came up with Zorazanan. I mean, we got 8 months, 7 months, 11 months, 15 months, 18 months, Morabel from 2000, 16 months of Robinson in 2008. You know, once you start getting on the computer then, you run the word months and Taranovich in 4th Department, or Jenkins then led to a bunch of these. This 14 month, assuming it's 14 months, it's not 8. I'm just dealing with that because that's in the court's decision. That 14 months is not unusual under our court's precedent at all, is it?
No, Judge, and to be fair, I would say that the factor isn't dispositive in either direction. So to be sure, there are cases that deal with a far shorter delay that the courts have found to be improper in the circumstances. But it underscores that it was not enough for the court to say 14 months, game over. I know that's not exactly how the decision reads, but it's clear from the decision that the court accorded great undue, I would say, significance to the simple fact of the passage of time.
But I'm sorry. But you're saying that this is a state police lab, and you're saying that's not chargeable to the people.
The state police retrieved the items of evidence, submitted it to the New York State Crime Lab.
New York State Police Crime Lab.
Yes, that laboratory has an independent function. Even under the CPL, for example, in discovery questions, it's recognized that the lab is not under the people's control, and they operate independently from the prosecution. They're not an arm of the prosecution.
Well, there's a case called People versus Jenny, Jenne, in the 3rd Department. And it really isn't pertinent here because that's a certificate of compliance Bay factor kind of case. But there, the records were in the possession of docs. And there, the 3rd Department cited to People versus Howard and another case that's slipping my mind now that talks about how the docs information is not part of law enforcement. So the fact that this originated in docs and the court below, the county court, faulted docs for not pushing it forward. Well, that's not really, one could argue under Jenny, not accurate because docs is not law enforcement. So with respect to the reason for the delay, there's not even any allegation of bad faith here. Not that that's the end all be all either, but there's no evidence even that the people did anything other than act in good faith. Once you get the case, under the new discovery rules, you've got to file a certificate of compliance.
That's correct.
And you've got to get it from a non-law enforcement agency. It's not like going to the holding center or the Alden Correctional Facility for your county. So you got to go through docs, and then it takes 7 months to do it. So the excuse for delay doesn't seem the way for the defendant. Our cases don't seem to think that this is an unreasonable delay for 14 months. There's no pretrial incarceration whatsoever except for a night or two when he's brought up from New York. And there's not even any argument that I see, do you, about there being an impediment to the preparation of the defense. The court didn't even say anything about that. Am I close? And give me the other side if you want to, Mr. Hillary, but to me, I'm having trouble with this one.
I appreciate Your Honor's thoughts, and just to steal the argument, if you will, for the other side, and I think that's the only way to go here. The defense would argue that there was prejudice in the sense that the defendant's rehabilitation was interfered with. In other words, he was out on parole release, and now...
Well, if you look at the Regan case, you don't have to consider prejudice if the first two factors of Taranovich are available,
well,
or in the defendant's favor.
And even if we get to prejudice, Prejudice is concerned with the defendant's ability to mount a defense to the action, to the charge. It's not, it doesn't look beyond, at least by the language of the fifth factor in Taranovich, it does not look beyond
Now, looking at
the
prejudice,
impairment.
didn't the defendant have to spend 7 months in solitary confinement?
That's,
Because of this incident?
that's correct.
And
That's,
now he's been released, he's on parole?
well,
correct?
Is
that accurate?
that is accurate. He's out on parole. He did do the 7 months, as Your Honor indicated, of solitary confinement. That was administrative.
Based
It
upon
wasn't-
this, well, they could have been presenting or preparing a case against him, and they didn't.
Well, I want to bring to the court's attention, as to the point about rehabilitation, the defendant
Is that
began,
even a factor under Taranovich?
I don't believe it is, Judge.
This whole mention of parole, the fact of the matter is, in your papers, you point out that the defendant, in fact, violated his parole in November of 2022. And if we consider that, but that's not even one of the 5 factors. And I thought prejudice had to do with impediment or impairment of the preparation of the defense. Not that you might actually go back to jail for a crime perhaps you're found that you committed.
That's
I'm
exactly.
having trouble with the prejudice. I'm sorry if I interrupted you.
No, Your Honor. That's exactly the people's position. I'm just trying to make an even-if argument, even if the court is correct in some sense, or was correct in saying, well, his rehabilitation was affected. Even looking at that, however, he received anger management treatment and substance abuse treatment beginning in April, I believe it was, of 2022. And so, let me make sure I have that date correct. I'm sorry, 2023, April of 2023. Now, the indictment was filed in late February of 2023, right? So there isn't this great period of time during which the defendant had been rehabbing, and now it's suddenly interrupted by this late-coming prosecution. It just wasn't true. He had a month and a half, a couple months in there.
Okay, I think we have that on here.
Okay, thank you, Judge.
Counsel, just one last point for my benefit. The county court actually found that this was a serious crime.
That's true.
I mean, that's not even seemingly debated on this thing. I mean, the fact of the matter is, we have plenty of cases where it's prison contraband, and the courts are, numerous cases where it finds that in itself is a serious crime. So seriousness weighs in your favor, according to the county court.
It does, Judge.
Thank you.
Thank you very much.
Thank you.
Good morning. May it please the court. Abigail Whipple for Mr. Kenneth Tyson. The pre-indictment delay in this case was unreasonable, and it denied Mr. Tyson due process. I want to focus on the reason for the delay. I feel that that's the dispositive factor here. So this was a simple case to prosecute. It involved just one video, a few photographs. And these photographs and this video were able to be preserved on the day that this incident happened. And obviously,
Those photographs didn't need to be in color, did they?
I'm not sure, Your Honor.
No.
Yeah.
Wasn't that part of the delay, too?
No. So that factor, I believe, weighs in Mr. Tyson's favor. I know there was discussion of the lab results, and I don't dispute it takes time to test a substance. But again, this was a very simple case. My position is that the time it took the state police to turn the case over was entirely chargeable to the prosecution. And then I'll just touch on the prejudice prong. As was discussed, Mr. Tyson spent 7 months in solitary confinement.
Where is that a factor under Taranovich? And doesn't the SHU not only protect other COs from having a dark-colored urine thrown on them, it also prevents the defendant from having interaction with the COs and maybe doing it again or otherwise be subjected to whatever the COs want to do. So it seems to me the SHU part is really not a factor under Taranovich at all. I've never seen that concept discussed in any of the cases. Have you?
So I was unable to find any cases where that was discussed. However, I think that speaks to that's one portion of the prejudice here. There's another component of the prejudice which was discussed a bit earlier, and that's Mr. Tyson, at the time defense counsel's moved to dismiss the indictment, had spent about 2 years in community anger management, domestic violence programming, substance abuse, and maintained employment as a
You
home
probably
care.
know this is coming from you, Ms. Counselor. But that, too, is not a factor in Taranovich at all. I've never seen that cited in a case, that his performance or defendant's performance on probation or parole is a factor. Have you found a case where that was a factor?
So I did cite a case in my brief that references, it says prejudice is not confined to a defendant's defense on the merits. And I might be paraphrasing a little bit, but that's the basis of my argument here.
But nothing to do with consideration of his performance or the defendant's performance on probation or parole. That's not a factor, correct?
That's not explicitly a factor, but my position is that this falls within the prejudice bucket. So unless the court has further questions, I'll rest on my papers.
Thank you. 721, People versus Jason Eckert.
Morning, Your Honors. David Abatoy for Mr. Eckert. Excuse me, I'm sorry. I have 2 points in my brief, but I'd like to focus my time here this morning on the legal arguments in point 2 with respect to the imposition of sentence. I think it captures some of the factual arguments in point 1 as well, so I think some of that will come up anyhow. It's our position here that the court took into account 3 improper sentencing factors when imposing sentence on Mr. Eckert, and we asked this court to reduce his sentence after having taken into account only the permissible sentencing factors and taking into account the information and position that Mr. Eckert put forward in the lower court. The lower court here used a kind of a triumvirate of evidence against Mr. Eckert to, we think, enhance the sentence beyond what it should have been here. And
Mr. Abatoy,
yes.
can I just slow you down without having you, don't lose your train of thought. I'm going to ask you actually about sequence, and I
Sure.
want to make sure I have this right.
Sure.
But if looking at the record, it looks to me like the court convened a sentencing proceeding
Yes,
and then took argument with respect to what was in the PSR.
yes,
And then the court really listened to the arguments, as I understood it, and then said, well, go ahead and make a motion, defendant. Defendant then made a motion, and that too was heard in a later proceeding, correct?
I believe that's correct, yes.
And then was there another proceeding where sentencing occurred?
Yes, I believe that sequence is generally
So,
correct.
Is it fair to conclude then, we can at least say that this court gave it a fair look?
I mean, I would agree that the court really looked over impermissible evidence. I mean, that's my position. The court very much dedicated itself to evaluating what these 3 types of evidence were, what was going to be offered before it, considered whether or how it should consider that evidence, and then went forward and did it after a significant amount of legal argument and encouragement not to do so.
But the court in its decision specifically stated that it did not consider the acquitted conduct, didn't it?
No, I disagree, Judge. I think.
Well, it's right in its decision, though. I mean, it's a quotation. As to the motion to strike acquitted conduct, naturally, that should not be held against the defendant.
But then.
The court said.
Later on, the judge says that she also then, okay, and so I guess at a minimum, this is confusing as to what the judge actually takes into account, and this is in part of our argument, which is that the judge says, I'm not taking into account acquitted conduct, as you've quoted from the record, but what she says is, I think she almost used the words, I'm informing you, I'm warning you, defense counsel, that I did find her credible, and I intend to take into account any credible evidence that I believe is relevant to sentencing. That implies the judge's analysis of the testimony given by the complainant at the trial, and the possibility that the lower court judge would take into account facts that the judge found to be credible despite the fact of an acquittal.
But
I
following
think,
up on that, Mr. Abdul,
Yes.
Justice Greenwood's question, I don't see this as anything close to the court expressly saying, I'm considering acquitted conduct. And there's a case I think you cite or addressed called Wilkman, I'm mispronouncing, it begins with a W, it's not from our court. But there, the sentencing court expressly stated that the court was considering acquitted conduct. And here we do not have that at all. Isn't that at least a fair statement that there's no express statement that for example, Here we have a situation, and it's even more important here, where it was a bench trial.
Right.
And the court acquitted, in particular, of count 3. And yet that was the main objection that counsel had to what was being considered the rape count, number 3, in the PSR. That was the main argument, as I understand it. So, but here the court heard that testimony and still found an acquittal. How can you then say in a bench trial, the court nevertheless considered it unless the court expressly says so? And we don't have that here. So confusion, I don't think helps you. What do you think?
Well, I think when the judge, well, I'll start by saying this. The court is only permitted to take into account permissible sentencing factors. So if the lower court, I think particularly in a bench trial, muddies the water with respect to this issue and makes it seem not only that all credible information will be taken into account, perhaps regardless of whether it relates to an acquitted count, and perhaps all credible information will be taken into account regardless of whether it's particularized to the defendant.
And this is where your argument, Mr. Abatoy, and you did a marvelous job in your brief. You researched everything. You showed the third department cases that go the other way on this acquitted conduct issue. I get it. But what really concerns me is when it's not expressed, when it's not clear on the record that the court considered acquitted conduct, we're going to be in this exact position case after case where defense counsel is going to argue, well, the court considered this because there's an inference from the record that says X, Y, and Z. I mean, I think under the third department cases, there's some rationale, and the federal approach. You could say, I'm not considering what you were acquitted of, but the facts and circumstances in this case all connect with one another. For example, a series of burglaries in the same neighborhood where the same type of stuff is taken.
Right.
You were acquitted of one, you were convicted of the other. I'm not so sure we can say out loud that you can never consider that series of possible conduct. So, you know, and here we don't have the court saying, I'm considering acquitted conduct, I'm giving you an extra year. That might be the case we need for you to make a more effective argument. Do you think?
It would be nice if it was more explicit. I suppose it would make it clearer, but I'll say this, Judge.
And I don't think you're going to say yes to that.
The lower court, I think, made it clear. So put aside for a second and just moving on to the second ingredient, I think, in the impermissible sentencing factors that were used. The court went on to say that it would use uncharged conduct to decide this issue as well. Effectively, any credible information, I believe it was the court who interjected the possibility that there were perhaps hundreds of other incidents that might go into the sentencing analysis here. And those are also, and I don't believe it could be any clearer on this subject, those are also issues that Mr. Eckert retains a presumption of innocence for. And, you know, kind of compounded in this case, and that's aside from the, you know, making it different and I think worse than the taking into account acquitted conduct. It's really undefined for Mr. Eckert, what he's defending against, what elements the court may have found credible. Just all we have is the fact that the lower court believes that there were hundreds of
Doesn't it make you a
instances.
little, I'm sorry, you
No,
first.
I was going to ask him to wrap up.
But doesn't it make it a little uneasy, at least, to say that we're going to have this situation where we're going to be inquiring into the sentencing court's mind of what did you really infer, or what did you mean by that? I have to tell you, Mr. Abbott, that makes me nervous. I don't know. How about you?
Judge, I think it's only relevant. I mean, it's interjected here. It's put in the fore by both the court and the prosecutor that these other things should be brought to bear and should be analyzed with respect to the appropriate sentence. It's in issue before this court. And perhaps this court doesn't want to nitpick every point of the lower court's discretion or any particular court's discretion. But when it's clear the analysis that's being made, I think it's fair for this court to examine what's done. And if I just go on to just finally on the third point, because I think it's very simple, Judge, with respect to the suppressed evidence. And this is one that's maybe a little less defined than the other in terms of what the jurisprudence looks like on this. It's our position here that 71070 tells this court, and the lower court should have known as well explicitly, that suppressed evidence is excluded, quote, through imposition of sentence. That's what the statute says. So it's our position here that as a preliminary matter, statutorily, no court can take into account suppressed evidence at sentencing. That's aside from the constitutional concerns that we've laid out as well. Thank you, Judge. Appreciate it.
Good morning, Your Honors. Ryan Ash for the people. It sounds like Your Honors have obviously looked at the issues here and I believe are all over my points. So if you don't have any questions, I would rest on my papers. Thank you.
722, in the matter of Jessica L. Cross versus Brian F. Cross. Just have to wait for Mr. Otis.
We have him, Judge. We're just waiting for him to turn on his camera.
Oh, okay, great. Is there an issue?
He should be able to hear us. He seems to be having a camera problem.
Can you hear me?
Yes.
I'm not sure why my camera's not working.
Do you want to proceed orally?
That's okay. I apologize.
Oh, no problem. You're solo today.
Oh, I didn't realize that. Okay. Well, should I just begin, Your Honor?
Go ahead.
My name's Scott Otis. I'm here on behalf of the children today. The kids and I really feel like they weren't given a fair shake in the trial below. I'll rest on my brief for the issues related to extraordinary circumstances argument and the AFC's substitution of judgment issues. I would like to briefly address the point in the respondent's brief related to the untimeliness of the AFC appeal. As you know, the trial AFC substituted her judgment for the children below, so she wasn't about to file a notice of appeal against her own preferences, despite the children's contrary requests. I received my assignment on July 12th. I met with the children on August 2nd. I filed my notice of appeal August 3rd based on what they wanted.
Well, Counselor, was it one child's contrary request or all? You said children's, but it was only one child, wasn't it?
No, although that is how it was represented below. All four of the children disagreed with at least some part of the trial court decision. The two oldest children desired to return to their mother's full-time care. The youngest two children, who have been with the custodians longer, were more ambivalent, but they still desired significantly more time with their parents than the trial court judge authorized. Again, I just wanted to emphasize I couldn't have filed their appeal any faster than I did, and I think it would be unjust to preclude their appeal just on that basis, given how the system is set up for replacement attorneys. Also, I just wanted to give you a brief update. I did meet with the kids most recently at the end of the summer. There are ongoing visitation proceedings at the trial court level. The mother continues to fight for her time with the children. Interestingly, the trial court judge has recused himself on these new matters. All of the children would like more time with their mom than the trial court order allowed. And again, the oldest two would like to be reunited as a family. Those are the main points I hope to highlight today in addition to my brief. Unless there are any questions, I'll rest.
So you're in front of a different family court judge now?
I'm not in the trial court. I'm not
you're
on
not.
the trial court proceedings, and it's in a different county than me, but I have contacted the mother's counsel regarding the status, and she tells me that the trial court judge recused himself and it's a new judge.
And there's a different AFC at the trial court?
No, the same AFC represents all three of the children. She has recused herself with respect to the one child that I think you were probably referencing.
Right, that begins with a G, right, yes.
Begins with a G, yes.
Yes, okay.
Thank you.
Thank you.
723, Gretel Kedley versus Terrence Kedley.
Good morning, Your Honors. May it please the Court, Charles Steinman on behalf of the appellant mother, Gretel Kedley, who is present in court today along with her family. I'd like to address two issues. First, the reversal by the family court of the longstanding and pre-existing separation agreements provisions with respect to custody and residency, and also the contempt finding which was issued by the court below. We submit the family court erred in essentially making those determinations and reducing Judge Mazzo's 55-page excoriation of my client to its basic elements. Judge Mazzo lays at my client's doorstep exclusively all blame for the fact that the younger child, names begins with F, did not wish to attend school in person after December of 2021 and refused to attend overnights with his father. I want to make it clear that it was not that the child had no contact with the father. There was extensive testimony about the contact. They texted, they telephone called, they had all kinds of outings. He spent time at the father's house, just didn't want to spend overnights there. There are a number of problems with the lower court's finding, which unfortunately, given my restraints of time, I can't go into, but they're mentioned in my brief. First, it's conceded that the younger child had serious mental health issues. He had a diagnosed anxiety disorder. He had a diagnosed...
We're aware of all of that.
Okay. And the mother sought treatment for that. Child had been seen by a therapist.
Now, let me ask you this. Didn't the mother, however, the father was hoping to encourage that they have family therapy so they could get through this and help this child and do it as a whole instead of all this acrimony, and she absolutely refused, and she would not do that. And then weren't there many instances where counselors actually tried to reach out to her and she refused and said she would not participate, correct?
As far as that goes, yes, but there's a lot more to it than that, if I may amplify on the court's point, Your Honor. This is out of context. There had been ongoing and multiple joint therapy efforts. They all failed. And as the AF's...
Well, some of them failed because the agencies wouldn't take them.
And is that the mother's fault?
I'm not saying that's the mother's fault, but
Right,
once they
but-
could get somebody, it was the mother's fault. The mother refused to participate. She would not participate in any Zoom therapy sessions, on any in-person therapy sessions. She said, absolutely, I will not participate, done.
She would go to the therapy counselor who handled domestic abuse situations. She was willing to do that. And she said to the court, and the father, I think, acknowledged this as well. It never, ever worked. It wasn't going to work, okay? And therefore, I fail to see how the court can hold a finding of contempt against my client on that basis. She said, you want to see a counselor? I don't think it's going to work, but I will go. In response to a direct question by the court, she said, I will go. I would like it to be this domestic abuse counselor who specializes in such matters. So to the court's point, Your Honor, that she absolutely refused, I would factually say that that's not supported by the record. She would go. She had gone in the past. And I say this in the brief, perhaps too candidly. At some point in time, we must recognize that some wounds cannot be healed, some fences cannot be mended. Okay? You can send somebody to therapy and join counseling. It doesn't mean it's going to work. Look at the past. It never did. And the father never said that it did. He acknowledged it never did. It wasn't going to. So to that point, Your Honor, if I may.
Why don't you go on to, is that to the contempt? Because you have to be mindful of your time, too.
Thank you, Your Honor. As to the contempt, there has to be an unequivocal court order that has been violated to the detriment to the prejudice of the offended party. That doesn't exist here. First of all, how can there be a finding of contempt that she alienated the children from the father? The testimony was uncontroverted. She tried to get the younger child to go see, the other one always did. She tried to get the younger child to go to the father. She always encouraged it. She thought it was important. Okay? She tried to get the child to go to school. Wouldn't go. And this is important to mention. Where's the father in all of this? If he thought he could convince the child to go to school in person, where were his efforts? If he thought he could get the child to spend overnights
He
with him.
wasn't seeing much of the child, number one, but,
I respectfully disagree with that, Your Honor. There was continuous contact between them. The child would stay there He just wouldn't stay overnight. It was texting, it was phoning, there was tons of contact. I respectfully submit that this record does not support that. And to the point that she failed to follow recommendations, what recommendation? The therapist who had seen him for 2 years said, we got to stop this. This just isn't accomplishing anything. So, and I don't agree that any other therapist recommended counseling, but even if they did, the mother is to choose between those two recommendations and make the wrong decision upon pain of contempt. It's absurd, absolutely absurd. Finally, Your Honor, with respect to the contempt, there has to be a demonstration of prejudice. For that to happen, I submit the father would have to show that had she agreed to go to counseling, it would have succeeded where in the past it never had. No such showing was made. Thank you very much, Your Honor.
Thank you. Who's going next?
Mr. Chacon is the appellant.
Oh.
And yes, I will be going by Chacon shortly. May it please the court. I'm Kelly Forst for the moment, on behalf of the children who will be 14 in December and 12. The younger child is now 12. I would remind the court that at the trial, both of the children's attorneys, there was one attorney for the children, they both wanted for the arrangement not to be changed, the custodial arrangement. Today, they're requesting that the court either use its considerable discretion to fashion a 50-50 custodial arrangement or to just simply revert to the prior arrangement, which was essentially 50-50. I believe Dad had, if you counted them up over the course of a month, it'd be 11, 12, or 13 days, and Mom would have the rest. So that was the original agreement that the parties themselves agreed was in the best interest of the children back in 2015 when they had their agreement.
Back in 2015, that they weren't even school-age children, right? Now they are, isn't that?
The older one was in kindergarten, I believe. He would have been 5, yeah.
Okay, kindergarten.
So correct, that's right. And to your point, Judge, I do believe that, there was a problem that I felt the family court felt she needed to resolve, which was that the younger child wasn't going to school. And I think that that was a large part of the reason for the decision, if I can read into the record, this enormous record. But that had already been resolved before her decision ever came out. Mom had made a plan and she had, put the plan into place, and that fall, the younger child was back in school full time before the decision was ever rendered. I think that was in November, and the child was back in school in September. It's undisputed that the younger boy has anxiety and an adjustment disorder. Both parents tried in their own way to help him with this. The family court, unfortunately, based much of its decision on mother's perceived failures to support a relationship between Finn and his dad. But as I described in my reply brief, there was simply not enough evidence for family court to have based its decision on mother's so-called alienation of the children from their father. In this case, nobody connects the dots as to either parent's causation of the child's behavior. I would like to clarify my position concerning the family court's abuse of discretion and limiting the proof to Judge Dollinger's order back in 2019. I do not submit, first of all, that the change of circumstances should be measured from any time earlier than that. The decision by Justice Dollinger that there had been no change of circumstances is now the law of the case, and that should not be disturbed. Instead, I submit that the evidence concerning best interests should have and could have and should have gone back as far as the first child's birth. If the court will indulge me for a moment, I'd like to offer an analogy about this. We all remember the tragic space shuttle Challenger disaster. Now imagine that Congress had directed NASA to appear at a hearing and to testify as to what went wrong. But the agency was only permitted to testify as to what happened from the time of takeoff to the time of the explosion. No witness would be able to explain fully or properly what had happened if they weren't able to testify as to the plans, design, materials, construction.
I think we understand
all
your
of
analogy.
Right? So in this case, respondent father says that most importantly, he says, the evidence did not substantiate mother's theory that father's conduct toward Finn is the cause of or a contributing factor to his anxiety. Parenthetically, that's the counterpoint to every alienation case. Either the favored parent is causing the child's behavior or the so-called targeted parent is, right? But neuroscience has come a long way in the past 10 to 15 years. It's now well established that a child's brain develops more connections and grows more rapidly during the first 3 years of life than at any other time. What happens to a child during those years lays the foundation for the child's
we
entire life.
understand all
I
this.
understand, Judge. Unfortunately, the younger child in this case is the very picture of how traumatic experiences, such as his parents' divorce, his father's alcohol use prior to his,
Understand all this.
the vandalism by his, who should be a trusted adult, a stranger, let alone who should have been a trusted adult. The death of his dog, which even the respondent acknowledges was a traumatic event for
But
the
trust
child.
me, for me, death of the dog is about the worst.
Right? And so this child has 5. We now know that children who have 3 or more adverse experiences are at an extraordinarily greater risk of developing mental health disorders, obesity, heart disease, and other serious physical illnesses. So when family court precluded mom from providing any of this evidence, they're saying, okay, give me
Family
half the
court
story.
was very well aware of all this, forever.
I'm sorry?
Family court was aware of all this, correct?
Well, not from the record.
Okay.
I mean, family court had a date, and I want to apologize to the court. I did misstate the respondent's date of sobriety. It was actually his wife's sobriety she was the one that was testifying to the 2016, not the 2014 date. So with all of that.
You should begin to wrap up.
Yep, I will. I don't suggest that the court remand this matter for additional testimony. I think it's going to be too difficult for the children and these parties. Instead, I would ask that you reinstate the prior residency schedule and use your discretion to perhaps add a Tuesday overnight on the weekends that Dad doesn't have the kids, so that he has closer to 15 days a month, so that it's an equal schedule. That is what the boys want. That's what they believe to be fair, and it seems to me what they think will end this conflict. Thank you.
Thank you.
Morning, Your Honors. David Abitoy on behalf of Mr. Kedley. First, the lower court has been over and through all of the factual issues before this court and made a thorough and reasoned decision. This court's authority to review those factual conclusions is mostly bound by the deference that that the case law on this subject describes. So I'd ask this court not to disturb any of those things. But if I could just respond to a couple arguments made by my opponents here. First, with respect to the therapy. The primary argument from the mother is that she believed therapy wouldn't work and therefore was seemingly justified in her refusal to not engage in it. Well, our argument here is that one very important person thought it would work and should be tried, and that was Judge Mazzo. She made a direct order for this to occur, and the mother, on her own, essentially decided that was not worthwhile doing. She wanted her own therapist, and I think shockingly said in court that one of the reasons why she wouldn't engage in this was because it would just give Mr. Kedley an opportunity to demonstrate his efforts in court to look good and to make an effort. I think that shows that the mother was essentially playing the system to try to defeat Mr. Kedley's ability to make a case, but in the effort of doing so, compromise the boy's ability to get the mental health care that he needed, and for the parents to try to comply with this order and go forward. So that's our response on the contempt. I would also note that although my opponents make much of their argument about whether or not, about certain factors with respect to the contempt finding on the therapy, that is only part of the lower court's contempt finding. I think the real meat and potatoes of the lower court's contempt finding is that the mother did not promote the relationship between Mr. Kedley and the boy, and that she actively did things to interfere with the relationship. And that was the subject of multiple orders and directives on which really no one could debate. So the mother has, I think, really not responded to that part of the lower court's contempt finding, and the thing that just makes it worse is all of the issues with respect to the mental health counseling. She was absolutely directed to engage in counseling, and the only reason why she wouldn't do it is because she couldn't pick her own counselor. If I could go on here, just to respond to a couple other things here. With respect to the school absences, and Mr. Steinman's argument that perhaps Mr. Kedley had not done enough to take the children to school or get them to school. The lower court noted, and the mother admitted her own testimony, that all of these school absences took place while the child was in her custody and care. That was an important part of the lower court's decision-making. And the mother is really the driving force behind the child not attending school in person for a long time. Although Mr. Steinman characterizes her testimony as having expressed some willingness to get the child to go back to school full-time, notably what she says is, words to the effect of, in her testimony, well, I'll ask him about it, or I'll talk to him about that, effectively including him in this really important decision with respect to his education, putting the burden on him of making that choice, and sort of leaving it up for debate in that area of fact where the educational and mental health counselors are all on the same page, which is that this kid should be going back to school, not that it should be left up to him or anything like that. If I could make one other point with respect to the lower court's limitation of the time limits that which should be discussed in the lower court proceedings. No one objected to that ruling when it was made. I think the AFC in particular tries to seek reversal of this issue on that issue and try to make out some off-the-record argument that there would be prejudice. There's no prejudice to anyone. It was never demonstrated. Everyone either consented to it or did not object. Seems like it was prearranged. So there's really no basis for this court to draw any conclusions about that the lower court should have done anything differently. Finally, I'll just note that with respect to the new evidence that the AFC has included in her brief, a reversal in this case, or any modification, would not return these children to the status quo as it might in some other case. From what we know in the additional facts, there would actually be a significant change for these children if there was some change in custody for them at this point, or any kind of disruption of what is currently happening for them. The lower court thought it was extremely important for these children to have some consistency, and I would ask this court to just continue on and allow them to have that consistency by affirming the lower court's decision.
Thank you.
Thank you.
724 in the matter of Cal LF. Could you please turn on your camera and unmute yourself?
I apologize. I do have my camera on. I'm not sure why it's not showing. I can proceed orally if Your Honors would like.
That'd be great. Thank you.
Good morning, and may it please the court. Jordan Shank of the Legal Aid Bureau of Buffalo, attorney for the child. I will rest on my brief, but I'm happy to provide Your Honors with an update on how the child is doing.
That would be great.
The child is now 4 years old. He does continue to reside with his maternal grandfather, whom he was placed with in February of 2021. He's very bonded to his grandfather and is thriving in his care, receiving both occupational and speech therapy. And just this last month, on September 25th, the appellant father consented to giving the maternal grandfather kinship guardianship of the child, and the appellant's visitation with the child was reinstated. Thank you.
Thank you. 725, Samantha Rodriguez versus Darren L. Young Jr. Just wait 1 minute. I'm having a little trouble with the camera, so let's see.
Yeah.
Ah, it worked.
Oh, yeah.
Hello. Okay, go ahead.
Good morning, Your Honor. I'm Charles Greenberg, representing Darren L. Young in his appeal from an order that was actually entered about just over 2 years ago on October 14th, 2022. The order provided for the relocation of the subject child born on June 30th, 2014, not 2024, 2014, to New York City. Now, the theory that Mr. Young would advance in the appeal was that the relocation was granted under false pretenses. And by that I mean the move to New York City, he had consented to the move to Tampa, which is much farther away than New York. It's in Florida, because he has family there, so Tampa was the second home. But she never found work in Tampa. She stayed in Buffalo, and then she lost the job in Buffalo. And her move to New York City was supposed to be temporary because her mother, who actually...
But then, when she got there,
Yeah.
she actually got a job, had a place to live, et cetera, correct?
Right. So she made the decision after she had arrived in New York City, but even that proved to be temporary because the mother, after she completed her cancer treatments in Brooklyn, went back to Milwaukee. So, I mean, I haven't had any recent contact with Mr. Young, but at the last time I spoke to him, she was actually no longer in New York City. She may have gone on to Tampa, she may have been elsewhere. So his thesis then is that the entire grant of sole custody and the relocation to New York City was made under a false pretense on the part of Ms. Young. Nothing untoward about family court for making it, but he felt that she kind of pulled a fast one on family court, and therefore that the...
But there's no showing that he tried to thwart the relationship, she tried to thwart the relationship with the father, is there, in the record?
Well, that's what's on the record is that they do have an acrimonious relationship and that there was very little communication between Ms. Young and Mr. Rodriguez. I'm sorry, Ms. Young and Mr. Young and Ms. Rodriguez. So I think that, and that there's also on the records that she also never sought to work within Buffalo. She was qualified for a number of jobs. She was working at T-Mobile for a while, and then when she lost that job during the pandemic, she never sought employment within Buffalo to keep the child in Buffalo.
Well, she had to go to New York to care for her mother. Right?
Well, she went. Well, I'm not disputing that she went to New York for that specific reason.
And
But
then
that's,
during that time frame, she found a full-time job and an apartment, and et cetera. And
but the move to New York was intended to be temporary, just for her, just for allow her to care for the mother. But the mother's no longer.
Wasn't the mother the primary caretaker?
The mother was the primary caretaker.
You know, and the father really didn't have a significant relationship with the child?
Well, he would dispute that because he in his theory, part of his
He had
theory.
no job and he had no, settled residence either, right?
Well, he was living with his mother for a while.
Well,
And
he said that, but then he didn't even know that the child was in New York for a while, correct?
that's correct. But he would attribute that to the fact that Ms. Rodriguez never told him that the child was in New York.
Okay. Anything further?
I know, unless there are any other questions, Your Honor.
Thank you.
Thank you.
Good afternoon, Deborah Jesse as the attorney for the child Cameron. The court is accurate. Mom went to New York City. It was during the pandemic. She had actually been living with the paternal grandmother for a while. So dad's mom, in fact, who he said he was always very close to. And when she first left, she actually left the child with the grandmother because she knew there was a court order for continued access for dad. Although dad, argues against this, mom believed that there was no contact while she was in New York between dad and the child. And in fact, it was the paternal grandmother who reached out to the mother and said that she couldn't care for these children. She didn't have any help. It was just too much for her. And that's actually why Cameron went to New York with mom initially. The substantial deterioration of the parents' relationship and the acrimony prohibited the court from continuing an order of joint custody. It just wasn't feasible. They couldn't even communicate without there being an argument. We support an affirmance of the lower court's rulings and the court's decision. Thank you.
726, Cindy Noss versus Gary Worth. Excuse me. And you're solo today.
Good morning, Your Honors. May it please the court, Carol Waldman representing Mr. Gary Worth. I ask that the court use its common sense when deciding these appeals. When common sense is used and the exhibits are examined in detail, it becomes apparent that Gary did not commit harassment in the second degree or disorderly conduct.
Does common sense not have us consider the bruises on her arm?
I think that the pictures that were submitted into evidence should be afforded very little weight because they're low quality. Some of them...
They do show bruises, correct?
They do show bruises, however, my examination of them, well, some of the issues with it are, first of all, there are no timestamps on them, and the metadata wasn't admitted.
Was it challenged at the lower level in that regard?
I can see that there were no challenges with respect to the...
So far. So I'm looking at them now, there's bruises there.
Correct, but as the court's authority, you can examine the evidence and give it the same weight as family court did.
Use my common sense, right?
And also with the photographs, I note that her hair color changes on sequential days, which I also think is problematic. I think that the family court also misinterprets the exchange between Cindy and her attorney on page 298 of the record, when family court concludes that it was a physical impossibility for Gary to reach for the keys in the ignition with only his left hand. Cindy, however, never said that Gary actually physically obtained the keys in the ignition, but that he grabbed for them. This is consistent with Gary's testimony on pages 393 and 394 of the record, in which he states that Cindy took the keys out of the ignition. With respect to the boat incident, I request that the court read Cindy and Scott's testimony.
Of course we will.
And listen to the actual audio in tandem, and it is clear that Cindy is the aggressor and instigator, not Gary. Gary is calm and controlled, and he is asking Cindy to go fishing with him and their sons the next day. He is not harassing her. Regarding the violation petitions, the 5-year order of protection cannot stand because Cindy did not meet her burden. For example, she made conclusionary statements that the entire marina is less than 500 feet. Yet using the cars in the picture of the marina as a unit of measure, it is clear that the entire marina is over 500 feet. And I just want to conclude by saying that the practical implications of the 5-year order of protection has devastating consequences on my client. I note that Cindy never even asked family court to prohibit Gary from the marina. This order has completely turned his life upside down. He can no longer work or live there, rendering him jobless and homeless. If the court decides to affirm family court's 2-year order of protection, I ask that the court at least vacate the 5-year order of protection and dismiss the violation petitions against him. Thank you.
Thank you. 728 Thomas Kingston versus Tennyson Court.
Good morning. Megan Roll from Lippis Mathias on behalf of defendants. Your Honor, it's respectfully submitted that it was error of the lower court to not dismiss the complaint. This complaint is insufficiently pled and it fails to state a cause of action. Specifically, we have a complaint that really asserts only 3 things in support of the 3 causes of action. Dates of alleged admission to the facility, broad conclusory legal allegations and statements that the defendants were negligent and that they violated Public Health Law Article 28, and the injuries. It really states nothing more. It's acknowledged that pleadings and complaints are to be liberally considered, but I would respectfully submit that it's difficult to construe facts and details that aren't there. Defendants are left guessing. We have no idea of the subject matter controversy. We have no idea what the transaction or occurrences are that are alleged to be the negligent conduct. And it's really unclear if there's even a duty. So it's very difficult to formulate defenses and affirmative defenses when you don't have specific details that are required to be sufficiently pled. With respect to the second and third causes of action, not only are they insufficiently pled, they also fail to state a cause of action, and that's supported by the documentary evidence that was attached to the motion to dismiss. This facility is an Article 46B adult care facility, which is alleged throughout the complaint.
Ms. Roll, that's the argument that has my attention at the moment.
Okay.
I found a case from the Second Department that neither party here cites called Broderick, 200 AD 3rd 840. 200 AD 3rd 840. And there the Second Department grants a motion to dismiss on the basis that the facility there was an assisted living facility. And motion to dismiss the same causes of action talk about here, 2801D and whatever, the statutory strict liability cause of action. And it specifically rejected a de facto residential health care facility argument. So looking at that, if we follow that, can we also follow Cunningham, or are they going in the opposite directions? Because Cunningham's probably your issue here.
Sure, and I'd love to.
And then you've got the Burkhart case that both of you address in your brief. Burkhart does a very thorough analysis of the statutory or legislative history, the statutory language, and says there that a group home is not a residential health care facility because it's under a separate section or statute, and it's not under Article 28. This facility, as an assisted living facility, and I don't think either party disputes it, is clearly not an Article 28 facility. But it is an Article 46B facilities argument. And there the definition under 46B says specifically, assisted living shall not include residential health care facilities or general hospitals. So it's not just that we have to construe the statute, it specifically says it's not part of it, which is what the Broderick decision relies on. So I'm sort of in a quandary on what to do here. Is this, I mean, could the plaintiff have made a motion to amend and added allegations to say, hey, you are providing health-related services? Or is it just as a matter of law, either on dismissal and summary judgment, that when it's an assisted living facility, that statute, 2801D, simply doesn't apply? Anyways, that was a really long question. I'm sorry for it, but I am struggling with this issue, and I'm looking for help from both sides.
Sure, and if I can take it in a few parts, I'll start by addressing, if you'll indulge me a few moments. Burkhart, I agree. That holding found that the mental health facility, mental hygiene facility was not an Article 28 facility. That's quite similar here, right? You have a statute that's explicitly stating that this is a 46B facility. There's dicta in the Burkhart decision that I think plaintiff relies on. That has nothing to do with the holding of that case. Cunningham, I think, is very distinguishable. I think that the Broderick case, and I'm embarrassed it's not included, however, I would submit that the arguments that we've made are exactly the same as that which was held in Broderick. Regarding Cunningham, the court, I don't believe and would submit, didn't make a finding that that facility in and of itself was governed by 46B. What I believe the holding in Cunningham was that the complaint sufficiently alleged facts to state a cause of action under 28. And I think that that's distinguishable. If you look at the Cunningham complaint, which I did, I pulled the record, that complaint is 12 pages, has 9 causes of action, 62 paragraphs asserting various facts. It alleges that defendant was a nursing facility for long-term care, and it specifically articulated that it was providing health-related services.
And there's nothing in the complaint here that even suggests that, except maybe boilerplate. Yes.
One time does this complaint refer to residential healthcare facility, and one time does it say health-related services. Now, health-related...
And it doesn't say what those health-related services are.
Correct. But if you look at the statute, the definition of health-related services is defined as physical care provided in a facility which offers lodging, in parentheses, Public Health Law 28014, Public health law 2801 refers to hospitals and residential healthcare facilities. Then when you follow the trail and go back to 46 facilities are not allowed to provide physical care.
Right. But Counselor, regardless of that argument, okay, we're here on the 3211, which it's not whether they alleged a cause of action, it's whether they could allege a cause of action.
I would submit
And
that.
so, to continue on.
Sorry.
So if they're alleging wrongful death, you don't have to, isn't it true that they wouldn't have to, correctly define what type of facility that's holding them, that either type of facility, a 46 or a 28, could be alleged to, be responsible for the wrongful death of a resident. And this is the earliest stage we're talking about here, we're 3211.
Your Honor.
So how do you survive that?
I would submit that the standard for a 3211 motion is not just whether it was pled properly. It's whether
I
plaintiff
didn't
has
say that,
stated, sorry.
No, I didn't say that, but it's whether there is a cause of action, not whether they pled one or not.
Correct. So whether they actually have a
Right.
cause of action.
Yes.
And I would submit that here, you're trying to fit a square peg in a round hole and say it's a cause of action. You cannot have a cause of action alleging violation of 2803 rights, which the legislative history of that, if you dive in, goes back to Governor Carey talking about the intent was to protect the rights of nursing home residents. They are then saying that the rights of these nursing home residents are the same rights of the 46B adult care facility residents. 46 articulates specific rights of adult care residents, which are separate and apart from the Article 28 rights. So I would submit that they have not properly, not only have they not, double negative, not only have they insufficiently pled an argument or cause of action, they simply don't have one under the statute.
Ms. Rowe, following up on that and what Justice Green was saying, so as opposed to pleading versus having one, if an assisted living facility can never be a residential health care facility, assuming they're not licensed as both, but assuming that assisted living facility can never be a residential health care facility, irrespective of the allegations of the complaint, make it a 5,000-page complaint about all the healthcare related activities provided. It makes no difference as a matter of law. They do not have a cause of action because they are not and can never be a residential healthcare facility. Isn't that your argument?
It is my argument. And I would also submit.
So Cunningham would be inconsistent with that argument, correct?
Well, I think that the standard on Cunningham was different because they were arguing whether or not it was sufficiently pled. And I think that the court holding in Cunningham was that plaintiff sufficiently alleged facts in the complaint to state a cause of action. I tend to believe that any inference that creates a cause of action is incorrect. But I think that's different and it's distinguishable from here because here not only is it insufficiently pled, but also it's our position that there was no cause of action. I don't know that was really an argument in the Cunningham case or if it was even looked at by the court in the legislative history of 28. Here, I would submit that our brief has really addressed that and is trying to make clear that 46B statute excludes these facilities as residential health care facilities.
Do you have something further?
Just briefly, if I may, to that end, regarding Mr. Hands. The only allegation against Mr. Hands is that he's a controlling party pursuant to 2808A. 2808A deals specifically with respect to residential health care facilities. Again, a facility that this is not, and it's excluded by the statute. So I would submit that too fails to state a cause of action explicitly as to him. And regarding Salem Buffalo, I would submit it's not even really addressed at all in the complaint or in the opposition or in the appellate briefs by plaintiff about how Salem Buffalo is in any way tied as the landlord. So I would respectfully submit that that too fails to state a cause of action. Thank you.
Good morning, Your Honors. May it please the Court. Jesse Drum from Brown Chiari for the plaintiff respondent. Just because this facility is an Article 46 facility does not mean that Article 28 cannot apply to it when it provides health care related services. When an Article 46 facility provides health care related services, they open themselves up to Article 28 liability, and that's what's happening here. They're trying to hide behind their operating certificate while providing and getting paid for healthcare related services in reality. And the plaintiff has pleaded that they agreed to provide health related services to the plaintiff's decedent. And this is a notice pleading state. We're not required to plead all of the different health related services that they provided, but we pleaded on page 6 of our complaint, paragraph 19, that they did provide health related services. And according to Cunningham, or under Cunningham, if we're following that, then that's all we would need to do to impute Article 28 liability upon this assisted living facility. And
what about the other defendants that Ms. Roll talked about? Do you disagree with her on that? They really shouldn't be part of this lawsuit?
I, of course, disagree because I think Article 28 applies. Right. And if Article 28 applies, Mr. Hands is definitely responsible. Even if Article 28 doesn't apply, there's still a negligence claim against him, and corporate officers can be held liable for their own negligence even while they're acting in their capacity as an officer for a corporation.
Yeah, but that's not alleged anywhere that he took any action. It's just the fact that he's a corporate officer, right? There's nothing more in there, is there?
Well, it says that he individually or in combination with the other defendants was negligent, grossly negligent, careless, reckless in causing injury to the plaintiff's decedent.
Right,
there's not details about this.
Right, there's no details. And
right.
What about the landlord?
Well, Ms. Roll calls it a landlord, but that's not what we pleaded, and this is a motion to dismiss, and what really matters here, what we're doing here is an analysis of our complaint, and in our complaint we have alleged that the Salem Buffalo owns and operates Tennyson Court and does business as Tennyson Court, which provided health-related services to Ms. Kingston. So taking all of those facts as true, which we're supposed to do in a 3211 motion, they own and operate this facility that caused Mrs. Kingston harm and was providing health-related services under Article 28, and therefore they're liable under Article 28. So they're not really a landlord. If you're reading our complaint, they're not simply a landlord. And if, when we get to discovery in the case, if Ms. Roll wants to build the defense or build the evidence suggesting that they had nothing to do with anything and they were merely acting as a landlord, we can do that. And all of these things can simply be denied in an answer, but they cannot be conclusively established at a 3211 motion to dismiss. These are factual analyses that we must do on these claims.
Anything further?
Not on that point, Your Honor, unless you have any questions on the other points. Thank you.
729 Pearl Street Parking Associates versus County of Erie.
Good morning, Your Honors. May it please the Court. Colin Knorr for the plaintiffs, appellants, respondents, Pearl Street Parking and Violet Realty.
Can I ask a question right off the bat? And it's probably more proper to ask your counsel here, but the order, while it denied the motion to compel the production of the report, also gave 30 days to get permission from the DHS. Did that ever happen?
As far as we are aware, no.
No, okay.
But
So
I
it's
would
probably
leave that to
not
counsel
proper
to
ask you, but I thought
answer.
maybe you might have a clue to this, but no, okay.
Can I ask a separate question?
Of course.
Do those barriers still exist? Those
Yes.
Plastic barriers, are they still there?
There is still a barrier prohibiting access. I'm not sure if it's still the plastic barriers. They've been replaced with something at this point. The case has been pending for a number of years now.
You're aware.
Because I know the photographs and the records show these plastic barriers piled on top of each other. Just wonder if those still exist.
I don't believe that they still exist. I believe it was something more substantial has been done, but that was done, again, after the complaint. At the moment, we're looking at the motion to dismiss based on the complaint at the time. I do want to address first the cross motion by the defendant's response appellants on that motion to dismiss. They offer two main arguments, the first being that what occurred was a taking, and the court below properly rejected that argument. Here on the motion to dismiss, the complaint should stand where, with every favorable inference, the facts pled fit within a cognizable legal theory. Defendants came before this court on a previous appeal and argued that no taking occurred. They've already acknowledged that the facts of the case fit into a cognizable legal theory that is not a taking. And since their argument is based on the fact that this must be a taking, it was properly rejected by the trial court. Even if there's an argument that there was a taking, there are significant factual questions that should be left to the trial court there. One is the fact that it's a stretch, in our opinion, to say that this could be a taking when the action was at the direction of the executive and carried out by the Department of Public Works, neither of which have the power of eminent domain. Eminent domain power is vested by state law and by the county charter in the county legislature. And it would be improper to allow the executive and the DPW to step out and exercise implicitly powers that they do not have, specifically under the charter. Defendants have acknowledged that the facts to be pled on a trespass versus taking are very similar. The question becomes one of the extent, the egregiousness, the permanence, and that's a fact.
We understand all that, and we'll look at that very carefully.
And as we pointed out, the case law that they've cited talks to much more severe and significant facts, but I won't waste time on that. I do want to emphasize that this is the scenario the Court of Appeals warned about in Corsello, that a entity that has the power of eminent domain should not be allowed to claim to its own benefit that its actions are taking and immunize itself from even defending a claim for trespass. The second basis for their dismissal is that there is no contract provision that the plaintiffs can cite to that have been breached. We disagree. We have asserted in the complaint that the actions have violated both the 1968 deed and the 1965 three-party agreement. The deed is a contract. Violation of a covenant of a deed is a breach of contract that has been recognized by this department, the First Department, the Court of Appeals. The 1965 three-party agreement does not include the county as a signatory party, but it does apply to the successors or assigns, and any person who owns the fee or right of possession or part thereof of the lands described in the plan for redevelopment. That includes the Rath Building, where the tunnel runs under, that the county owns.
We understand that.
And because the agreement was filed in the chain of title, the county was aware and acknowledged that when they took title and assumed those obligations. If the court doesn't have any further questions on the motion to dismiss, I'd like to address our motion
Why don't you go there?
to compel. County defendants are relying on a site assessment report that was prepared by the Department of Homeland Security to justify their actions. They acknowledge that report was responsive to the discovery demands. The only basis for refusing to produce it is that it is labeled protected critical infrastructure information under that federal law. The court below found it was discoverable and that the county was required to request permission to disclose it. Our assertion is that there is no need to request permission. The county has the full authority to consent to that disclosure. Under the PCII statute, the keys to the safe are in the hands of the entity submitting information. An entity can...
This gets a little different. This is an odd argument, but it gets a little different, because now it's the site assessment that we're dealing with, not just the original. So while the county has to give permission initially, there is that part that may involve more than that.
Well, Your Honor, to
That
that,
makes sense, if I'm not being very articulate, but I think you see what I'm saying.
yes, under the regulations, what can be deemed PCII is the information that's submitted or discussions about that information. Those are the only things. There is nothing in the law that allows DHS to separately mark it as protected because they want to protect their work product. That does not exist in the federal law or the regulations. To the extent that the report is marked PCII, it is because it contains that information that was submitted by the county and contains discussions about that information, whatever the DHS analysis was. But there's nothing in the law that allows the DHS to put its own protections that it has to waive. The protections are only on the submitting entity, and there's no indication in the record that this report includes information submitted by any other entity than the county. The county previously provided a copy or a excerpt of this report to the trial court below for in-camera review, and they advised that they had the authority to disclose at least the parts of the report specifically addressing the tunnel.
But not all of it, that was
But at this point, they're asserting that they don't even have the authority to give us the parts addressing the tunnel. When they previously advised the court they did. They have not offered a basis for why they maybe thought they did and no longer do, or have lost that authority.
Mr. Norr, is there any sense that this report, or whatever the federal government did or didn't do, will be used as a shield and a sword? That is, not only can't you get that information, but do you think the county could then turn around and testify at trial, put in evidence at trial that, hey, but the federal government told us to do it? That strikes me as being a real problem for your side of things. So is that what you're worried about? I mean, it seems to me if we never got this, and the county never claimed that this was something the federal government made them do or advised them to do, then why do we care about this?
Well, to that point, Your Honor, that is specifically what they have already asserted. That is the position that they're taking, that they had no choice but to close the tunnel and to exclude PSPA from its property rights because of this report that was prepared years before they took that action.
All of which would be hearsay and inadmissible, presumably.
That may be the case if we get down.
I'm ahead of myself, I forgive me, but I'm just in terms of that issue, I'm trying to figure out why this is such a big deal that you're up for an appeal, but I realize you're just looking at look at the merits. I get it.
Yes. Certainly, if the report is out entirely and no one's going to use it, that may change the position of the case going forward. But as of now, that's been the county position. And what this court said on the last appeal was that the justification is the biggest remaining issue in this case.
Okay, and we're going to look at that so carefully. It's a very interesting issue.
And just, I guess, to briefly touch on the depositions, this is the appeal by the defendants of the depositions that were granted in our motion to compel Daniel Naberth as the representative of the county. The plaintiffs properly identified him as a requested witness under CPLR 3106D. The county does not dispute that they did not offer an alternative within the time frame required by the CPLR. There's case law out there that's been cited that says that the municipality has the right in the first instance. That case law is erroneous to the extent it relies on cases decided before the 1984 amendment to the CPLR. Cases that apply the amended statute properly determine that it is the right of the plaintiff to identify an individual. The opportunity is to object and provide a different individual at least 10 days ahead of the scheduled deposition. If you fail to make use of that, there is no argument that you've been prejudiced. And to the deposition of Mark Polenkar as a named defendant, we don't believe there's any basis for a named defendant to refuse to appear for deposition. The case law cited by the county addresses depositions of an individual who was dismissed from the case as named defendant before the court decided to apply the high-ranking official test. Even under that high-ranking official test, the two questions are, does the deponent have information that can't be obtained from another source?
I'm not even sure if that applies, but go ahead.
The decision was made by the county executive. He is the only one who can testify to that. county has offered no basis for why a deposition would interfere with the execution of governmental duties. And we've offered documentary evidence showing that the executive has free time and can certainly use that to appear for this deposition. Unless the court has further questions, we would rest on our briefs.
Thanks. You know the first question I'm going to ask you. Did you or did you not request permission from the DHS to disclose the report?
We have not made that request from DHS.
So you were given 30 days and you didn't bother to do that?
By operation of the CPLR, a municipality is subject to an automatic stay when an order of the Supreme Court is on appeal. And so the opposing party and the court has been aware of that and aware of the grounds for our failure to do so. There's been no subsequent application to force any further action by the county, by the plaintiffs. James Blank, on behalf of the defendants' respondents. I want to get into, I'll start with the matters that of dismissal. Why this complaint should have been dismissed, which I think moots out all the discovery issues. As it pertains to the breach of contract action, there are certain exceptions to the merger doctrine for two classes of cases. One, you have a vendor-vendee breach of contract action. You have the actual parties that are in privity with each other by virtue of a purchase and sale agreement or the like, except for the fact that the merger doctrine would generally render it unenforceable, except in to the extent that it was evident in the documents that it was intended to survive closing. That's not the case here. There's no privity by deed, by grantor-grantee relationship. There's no privity in the 1965 agreement. It's simply inapplicable. Nicholson is the controlling case on that says the grantor's contractual obligation would need to be expressly assumed in the deed. And as you could see at 73 through 76 of the record, there's no assumption of the 1965 agreement. There's nothing in this case that's distinct from any other restriction on use, any other interest in property that runs with the land. Now, on that issue, running with the land, litigating property interests that run with the land, there are some cases that say that you can look to extraneous documents to substantiate an aspect of that property interest. It does not follow from those cases, however, that a cause of action for breach of contract runs with the land. That's what we're dealing with here. By the plaintiff's interpretation of case law that really doesn't support their position, there would be no property interest that wouldn't be equally enforceable by breach of contract action. We see in the CPLR there are different statute of limitations for breaches of contract as there are from. Yeah. And finally, on the breach of contract, it's implied by this court's prior decision in this case. The complaint, the verified complaint, was before this court. That was, admissible evidence on a summary judgment motion, and this court concluded that the plaintiff failed to establish a prima facie case of a breach of contract. The court recognized in its prior decision that this is really just reformulating a property interest dispute into a breach of contract, which does not lie under New York law. To the cases to the issue of condemnation taking, when this suit was filed, to Justice Montour's question about there were plastic barricades, they've now been replaced by bollards, I think that's the term, the construction term. It's a more permanent physical.
We're aware.
What's that?
We're aware of that.
Yeah, many of us have driven by it. By the time this case was filed, It was 4 years after the entry, the interference with the easement. The rule is that an inverse condemnation occurs when there's a permanent ouster or permanent interference with the property interest. That's Weaver, 183D 920 from this court in 2003. What do we have here if not an ouster? By the time the complaint was filed, for 4 years, the plaintiffs or the plaintiff's predecessor in interest had no opportunity to use the easement under the Rath building. The cases that the plaintiff points to cases where, it's not really clear whether it's a permanent interference or a passing interference, and we should leave this to a question of fact. The cases cited by the plaintiff are simply not on point. We have FMC Company versus Driscoll, Feeder versus Village of Monroe. These are intrusions, these are physical intrusions, but they're physical intrusions that are attendant to temporary work, construction work. There's construction work going on there. I think they both happen to deal with bridges. There's work being done on the bridges that's causing an interference with the property. In other words, the interference isn't there to create the interference itself. It's not in and of itself, it's an ouster. It's an interference that's attendant to ongoing governmental work. We've cited Sarnelli, which I think is on all fours with the infringement here, where you have a fence that's being put up. That is the taking. That is the cause of action accrues when those barricades go up. There was never any indication that there was anything attendant, there was any sort of secondary concern or any other reason for the barricades going up in the first instance, other than to exclude use of the easement, in other words, an ouster. To the question about the power of eminent domain, de facto takings cases necessarily do not involve an act by the legislative authority. The most common instances of a de facto taking are always accomplished through the act of an agent. You have, whether it's in the context of a utility or in the context and I would just note in the complaint, the allegation against Mr. Poloncarz is that he undertook this action in his power, in his capacity as the county executive of Erie County. There's this, obviously, he's advancing it's an action he was taken on county property to the detriment of an adjoining landowner. There's nothing personal in his action. There was nothing personal in the actions of the Public Works Department in creating the barricades. It's a classic de facto taking.
Would you do me a favor and go to the disclosure issues?
Yeah, of course. The site assessment report, Your Honor, as a preliminary matter, the determinations of the trial court are subject to the discretion, are subject to an abuse of discretion standard. We've addressed some of the case law. The fact that there is a statutory interpretation that's secondary to a discovery dispute does not change the standard. The cases, I think, are very clear on that. When we're dealing with statutory contours to a discovery dispute, it doesn't render it an issue of de novo review for this court, and that's for better or worse from my posture. As it pertains to the depositions of Mr. Poloncarz and Mr. Neverth, the idea that the county's right to identify an appropriate party is not something that it was somehow waived is not something that was brought to the prior court's attention prior to this, and it's not something that I saw in the briefing on this issue, and it's not something I think that certainly that the Supreme Court relied upon. It's clearly the right of the municipality to designate an appropriate individual, and to the extent that that individual does not have enough information, then there's subsequent proceedings or subsequent conferral to determine whether the deposition of somebody as high-ranking as a county executive should be subject to deposition.
Well, there's no substitute that was offered, was there?
It's the county's obligation. This was not noticed on subject matter. It was not a notice to the plaintiff to say, we want somebody to, or to the defendant to say, we want somebody to speak to X, Y, and Z, and then we designated somebody who they wanted to have deposed. They just sent out a deposition notice to county executive pulling cards.
Right, then they had a time frame within which to substitute someone else.
There was no conferral on timeframes. There was no request for a substitute. There was no substitute presented. I don't think that the onus is not on the municipality to identify a person who's going to stand in for a person. Now, if we're noticed on subject matter, we want somebody to talk about the decision underlying the construction of barricades, then that's obvious that we need to create a person. They might not be happy with the person, but it's the county's right to designate that person, and then subject to further conferral or further depositions as necessary. To the site assessment report, Your Honor, it is an interesting and difficult decision, but I think the Supreme Court was absolutely right. This document that we're discussing was designated as PCII by Department of Homeland Security. It is the work product of Department of Homeland Security. The security implications and ramifications of that work product can't really even be anticipated by the county as recipient of that document. There could be all manner of information that could be gleaned from this that DHS might oppose the public disclosure of. And so the proper approach is to recognize that the consent of the municipality is necessary but not sufficient to compel the disclosure of the PCII. We see no issue with the way that the Supreme Court treated that issue, and we think that portion of the order should be affirmed. There's some additional discovery issues that we think that should be affirmed, based on conflicting and shifting interpretations of discovery requests. That the discovery itself says something. The motion to compel seeks documents that are outside the plain interpretation of those demands.
We'll look at all that.
Those are all matters that should be subject to the discretion of the court. Unless your honors have any further questions for me.
Thank you.
Thank you.
7:30, Sanders versus Sanders. Oh, I'm sorry. Let's see if the camera works for Mr. Hoffman.
He's still coming over, Judge.
Thank you. There he is. Mr. Hoffman, could you unmute yourself, please? Can you hear us? Can you see us?
He's got to lower his camera or sit back.
No, if he can't hear me, it's not going to be good to tell him to lower his camera. I do not sign language. I think we have a power. Can you hear us? I don't think me talking any louder is going to help.
Uh-oh. We're limited on our side what we can do, Judge, but they never unmuted their microphone.
Now can you hear us? Is there any way to get a hold of them?
Can the court hear me?
Yes. Can you hear us?
I can, yes.
Okay, now we can't see you.
I know you can't, but I'm here.
Now we can see you now. Why don't you go ahead?
You can see me?
Yes, we can.
Okay, I can't see the court, but I'll go ahead, all right?
Don't worry, we're not worth seeing, okay? As long as you can.
All right, first of all, thank you, Your Honors, for having the patience to listen to us after all these other cases that you heard. I was asked about 2 weeks ago to present the oral argument before the court by the plaintiff. So I put together as best I can after reviewing all of the records that were available to me to make this oral argument, okay? First of all, I noticed that the plaintiff did not appear to appeal the denial of her motion for a default judgment. So I don't think that that's an issue that this court needs to consider based upon my review of the record and the submissions. But as far as the dismissal of the case pre-discovery, we have some issues with that, Your Honor. So there's a procedural argument here that I would like to present to the court. And obviously, I don't need to educate the court on the difference between a motion to dismiss and the motion for summary judgment. But
Oh, please don't. We do. We're all aware.
Okay. All right. So, but the thing is here is that this case was the defendant made a cross motion for a dismissal, a motion to dismiss, not a motion for summary judgment. And we think that it was error for the court below to grant that motion pre-discovery, because it's our position that summary judgment before discovery is not permitted if a valid cause of action for breach of fiduciary duty is asserted. Also, the parties must be given notice by the court to convert a motion to dismiss to a motion for summary judgment. And I refer to the court, this old court's case of Smith versus Smith.
Mr.
Flip
Hoffman?
opinion 2478.
Mr. Hoffman,
Yes.
can you hear me? Mr. Hoffman, can you hear me okay?
Yes, I can.
I think you can go on to your next argument because, at least for my part, I see nothing in this record where a Supreme Court granted summary judgment. It clearly expressed itself as granting a motion to dismiss under 3211A 1, 5, and 7. So that's, I mean, I don't see where there's any real argument here about what it did. So if you could just go to the next thing about, especially 3211A 7, my curiosity in this case in particular has to do with the bases for the court granting the dismissal, essentially finding that the plaintiff had no cause of action as opposed to whether or not she stated one, based on the documentary evidence of the judgment and the transcript of the stipulation. I'm not so sure that that was appropriate, and I would like to hear your argument on that.
Okay. Yes, thank you very much, Your Honor. First of all, our argument is there is a fiduciary duty between spouses in a divorce proceeding.
Can you hear us?
Frozen.
Here I go again. I'm yelling at them like
Solis versus Solis, TSOLIS, 87 AD 3rd 889, and then the Family Court Act, Section 424A. So I think that there is a fiduciary duty, even though the spouses are separated and there's a divorce action pending, there's still a fiduciary duty between those spouses to be honest and forthright in their disclosures.
Well,
Our next
regardless of-
argument is, excuse me,
Mr. Hoffman, irregardless of that, that if you're alleging, or your client's alleging fraud, correct, in this settlement, so if there's fraud, I mean, you don't even need that fiduciary duty, do you?
well, you probably don't. Yes, I understand it. There is many cases that talk about fraud, that's independent of any kind of a fiduciary duty. That's correct, Your Honor. I don't disagree with that.
So why don't we go with the fraud?
Okay. Well, my next argument is further investigation by a spouse in response to statements or representations made by the other spouse is not required without then current knowledge of actual fraud. A mere suspicion of fraud is not enough. Okay, so and I've got some case law on that. EICHOLZ, Eckholtz versus Eckholtz, 188 AD 3rd 820, Appellate Division. That's a 2020 case.
Okay, why don't you
Then
go
there's a
back
federal case that says under New York law, one who has been induced by fraudulent misrepresentation to settle a claim may recover damages without rescinding the settlement. Contrary to the defendant's argument, we are not trying to rescind the entire settlement. We are just trying to go forward on the fraud as to how that impacts the settlement itself, but not to rescind all the elements of this settlement. So in other words, the fact that she accepted some benefits from the divorce action, from the stipulation, does not mean that when she discovers fraud after that she can't reopen the case to the extent of addressing the issues of the fraud. So this federal case is that I cited as SLOKIN versus Citizens Casualty Company. It's 614 Fed 2nd 301. That's pretty much it, Your Honors. That's our argument, that there's a fiduciary duty here. There was a breach of that duty, and this is a valid, and you can't waive that. So,
Okay, I think we understand your
Yes,
argument. Thank you.
thank you very much.
Good morning. May it please the court. Lee Alcott, Barclay Damon, on behalf of the defendants' respondents. I'd like to begin by setting the table for this case. The plaintiff appellant in this case is a disbarred lawyer, a convicted felon.
We know that, Mr. Alcott, as you know.
So I would say,
If we evaluated a case just on the basis of that, but we can't do that, right? We got to look at the complaint, and we got to look at whether or not the court made a mistake with respect to granting a motion under 3211, 1815 or 7.
correct.
What's getting to the merits, at least for my part, what I'm curious about is, it seems to me Supreme Court essentially said that plaintiff was on what I'll call notice inquiry and didn't follow up. But I've looked at a lot of different cases, and I don't see this case as being a situation where a party has said, Judge, I'm satisfied with what I have, and I waive any other discovery. I'm not going to do anything else. I'm done. The first part's there. The second part about a waiver of any further discovery and saying, I know there may be more stuff out there, I'm letting it go. It's like what the language in a general release that sometimes says, I'm releasing all claims of which I'm aware and those that have not been filed. You know the language. It's been a while since I drafted one, but you know the language. So even if I don't know about it, I'm waiving it. I'm walking away from it. I'm releasing it. We don't have that here, do we?
I think we do, Your Honor. If we look at the colloquy between the court and the parties, when the court asked the plaintiff, are you satisfied with the discovery that's been had? Defense counsel, or rather, actually, it's Mr. Hoffman, who appears today, said, well, we're satisfied with everything that we've received. And the court says, wait a minute. I'm not going to sanction this agreement unless I have an unequivocal yes. And Mr. Hoffman deflects it again. She says, very well, we start trial at 9 o'clock tomorrow. Whereupon Mr. Hoffman says, yes, we're satisfied. Mrs. Sanders says, yes, we're satisfied. My client says, yes, we're satisfied. My point is, Your Honor, that a deal is a deal. Stipulations of settlement are very heavily favored by the courts. If this court, or any court, allows someone to go forward 4 years later and say, well, wait a minute, I've come up with all these things, and I want to name his current wife, which is really bizarre. And if you read the allegations, they're just all over the place. All over the place. You can't come in and say, the earth is flat, the moon is made of green cheese. These types of things.
Go ahead. You
No,
please.
but I'm saying, but if there's an allegation of fraud, isn't that an exception to what you're talking about?
If there's an allegation of fraud that has some substance behind it. But here's just no substance behind it whatsoever.
Mr. Elkott, I spent a lot of time with the complaint, and I sort of appreciate some of what you said with respect to the allegations of the complaint. But then I started boiling it down to the allegations that certain assets were transferred to others, the mother, some person other, and that was used to secrete or hide assets, so that the discovery that would have been exchanged in the matrimonial would have been fraudulent because they didn't disclose those. The money that was allegedly invested into properties that was taken away from the marital estate and put into properties that belonged only to the husband, that supposedly wasn't disclosed. Again, I'm not saying it's a winner, but I'm just saying in terms of where we are now on a 3211A7 motion,
I understand.
don't we have to see whether or not there's a potential that the plaintiff has a cause of action, given what she has alleged here?
I contend no, Your Honor, and one of the reasons is her excuse for not having ascertained this is the plaintiff had no standing. I don't even know what that means. The plaintiff had no standing to investigate this. You come to court, you've done discovery, you've had all the discovery. He has paid her close to $1 million. The court's decision in Reader versus Reader tells us that when you accept the benefits of a settlement agreement for 15 months, you've ratified the agreement. She waited 4 years after this agreement was entered into. We're now 8 years after the agreement was entered into. He's paid her $1 million. He gave her the balance of his 401k account. He gave her a piece of property. What more can he do? She's never going to be happy. We know the type of person she is. And if the court reverses, now we're going to have discovery taking place. We're going to start all over again on a matter that was resolved back in 2016. And I don't think that's something that we want to do here, Judge, respectfully. It's going to create just a floodgate of case where people are saying, oh, yeah, I entered into that, but I've got some new allegations of fraud. And they can make up, say whatever they want, and all of a sudden now every stipulation of settlement, which is a binding contract, is now open to attack. It would set, respectfully, Justice, it would set a very dangerous precedent. And we suggest on that basis, Your Honor, the order should be affirmed. I'll take any other questions.
Thank you.
Thank you.
731, Paul Piotrowski versus Town of Cheektowaga, and Judge Monshore is recused on this matter. Let's see how that video comes up on this one. It is, right? Ah, hello, we're glad to see you. Okay.
Good morning for another 2 minutes.
Good morning, or good afternoon, Your Honors. Kevin Loftus, may it please the court on behalf of the town of Cheektowaga. The town made this motion under the prior written notice statute. 2 minor points I'd like to begin with. I don't think there's any question that we did not receive prior written notice. We submitted the affidavit of the town clerk, and we submitted the deposition transcript of the highway superintendent. Neither individual received prior written notice. We also
But the town highway superintendent testified that he didn't search the records of the highway department. That's in the record.
Right, but he also testified that he was asked, did you ever receive any notice regarding this particular corner? He said no. We've never received any notice with respect to this particular corner.
But he, once again, did not search the records, and he testified to that.
He was.
So that's his testimony.
That's his testimony. He could only answer the questions that were asked of him. With respect to the prior written notice, we've submitted, it's our position, we've submitted evidence from behalf of the town clerk and the highway superintendent that there was no prior written notice for this particular sidewalk. Okay? The next point is with respect to whether this falls under the prior written notice statute. The plaintiff's respondent's brief does not mention or reference the prior written notice statute at all. The respondent's brief solely indicates that they're opposing on the sidewalk statute. The sidewalk statute has nothing to do with the town of Cheektowaga's appeal. That is the Carlucci appeal, and that has nothing to do with the prior written notice. Once we establish that there was no prior written notice, it is the plaintiff's burden, as we point out in our papers, where they have to prove that there was some immediate defect after an act of affirmative negligence on behalf of the town. Now,
well, the factual allegation here isn't that it was the sidewalk itself that was defective. It was this this plastic.
It's an ADA ramp.
Right.
Right.
And it's an ADA ramp, and it's sometimes they're called
It's a tactile they refer to.
Tactile,
Yeah.
right.
Right.
And the first department has said that the curb ramps don't apply to their prior written notice, correct?
Correct, but this court has said just because a term is not listed in the prior written notice statute, this court has addressed stairs. Stairs are not addressed in the prior written notice statute in certain municipalities, but they've said, this court has said, as long as it acts as a functional equivalent of a passageway, a functional equivalent of a sidewalk, and it provides passageway for residents, it should fall under the prior written notice statute. Whether that ramp applies to the sidewalk statute, and Ms. Roloff will argue that is a completely separate issue than what we're dealing with respect to the prior written notice statute. I think there's overwhelming case law that just because a term is not listed, ADA tactile ramp is not listed in the prior written notice statute, but it acts as a passageway for residents, and courts have held that area would fall under the prior written notice statute. Once we prove that there was no prior written notice, it is the plaintiff's burden to show that there was an affirmative act of negligence that immediately created a defect. On that issue, they present two experts with completely contrasting opinions. They talk about visual cues, they talk about pedestrian vision angles, they talk about contrasting colors. That has nothing to do with the defect that we're talking about right here, which is the crumbling of the ADA ramp. Nowhere in their brief or nowhere in their expert reports, they actually talk about the actual defect, which is that crumbling concrete. And this court's been very consistent on this issue, is that once we prove that there was no prior written notice, it is the plaintiff's burden to show that this is not a condition that developed over time. And on this issue, we have the greatest piece of evidence, is that 2012 photo. The 2012 photo shows that this tactile ramp was completely intact 3 years after its installation. This is not one of those cases where, as a defense attorney, I say, I really wish we had a picture of the area where, this accident occurred. We have the picture. We have a picture 36 months after the installation. And the record is, and the appeal is straightforward. 36 months, and then in 2020, it was defective. It was crumbled. We have no idea how, or more importantly, when, for the purposes of this appeal, that occurred. We just know it didn't immediately occur after the 2009 installation. So, if the court has any other questions, I'll rest of my papers.
Good afternoon. May it please the court, Jill Allen, formerly Roloff from the brief. I represent the Carlucci defendants. Your Honors, we're not dealing with, and I think Justice Greenwood, you already pointed this out, we are not dealing with a slip and fall or a trip and fall on a sidewalk. It has been conceded both in plaintiff's opposition in its brief to this court and also in the underlying papers to the court below or the trial court that this fall occurred on the plastic tactile that it is embedded into a corner curb ramp. The corner curb ramp and the sidewalk are not the same thing. And that is because of that fact and that concession by the plaintiff in opposition It is our position that plaintiff has not created an issue of fact as to whether the Carlucci defendants, which are the property owners here, and not the property owner of where the incident occurred, but they're the abutting landowners, have any sort of responsibility or can be liable. And the reason for that is this is town land. That point is undisputed. The area where the incident occurred is town land. It's within the town right of way. Therefore, in order for the Carluccis to be liable, the town must have delegated the responsibility to the Carluccis to maintain that area, and they also must have explicitly shifted liability for any injuries that are caused as a result of a defect on that area. We don't have either of those things here. And really just the last point is that plaintiff's opposition is in essence that there is a question of fact on whether the Carluccis were responsible for this area pursuant to the sidewalk statute or the code that says that the Carluccis are responsible for the sidewalk or that they'd be liable for injuries of the sidewalk.
But this isn't the sidewalk.
But this isn't the sidewalk. Not only is it not in the definition in the code, the legislative intent from the town of Cheektowaga, they could have put in a tactile or a curb ramp once the town installed both the curb ramp and the tactile. They could have put that in the code that says that the sidewalk extends to these areas. It didn't. And the cases cited in my brief from the Court of Appeals and also from this court, it says that if there are any ambiguities in the language in a town code, it must be resolved in the favor of the homeowner. So in this case, that would state that the homeowner did not and was not responsible for maintaining the area where this incident happened, and also more importantly, that the town did not shift liability on the homeowners for incidents or injuries that occurred as a result of a defect on the area in question. Thank you.
Can everybody hear me?
Yes, we can, and we can see you.
Okay, good afternoon. Kristen Tishy from Desmond Law for the plaintiff respondent, Paul Piotrowski. I think each of the issues that were brought up now this afternoon are addressed pretty thoroughly in our briefs. I know everybody probably is ready to go, but just quickly, with regard to the prior written notice issue, Mr. Loftus keeps saying that there's no dispute that there was no prior written notice. I don't think that's true. I think, and we've laid it out pretty thoroughly, that the notice issue hasn't been proven by the town. They didn't come forward with information from the superintendent saying what was looked at. The town clerk didn't say what time frame she searched. She didn't say what specifically she searched at the clerk's office records. And the case law is pretty clear that those have to be done when the code specifically says that reports of a defect can be made to the clerk or the superintendent. And in this case, Mr. Loftus just said he can only answer questions that were asked of the superintendent, which is interesting because following Mr. Crystal's testimony, an affidavit was submitted. It contradicted his testimony, but an affidavit was submitted saying something different. In this case, no affidavit was submitted from the town superintendent whatsoever. Whether the question was asked at the deposition or not, the burden is still on the town to prove that those records aren't there. And all they keep saying is, well, the records are old, we don't have them anymore, which is interesting because they found a record from 2009. So if the records are only kept for 7 years, how come they were able to find this one? It's just inconsistent. And as far as the allegation that the experts' opinions are conflicting, I would disagree. The town's entire case rests upon this 2012 photo, which is pulled from Google Earth, despite the fact that their own employees are saying they have no idea what happened between 2009 and 2012. Mr. Crystal testified at his deposition that he didn't know what happened between 2009 and 2012. And at his deposition, he initially said he didn't know when that tactile was put in. I realize he said something different in his affidavit, but he very clearly testified that he did not know. So in that photo, according to our expert, that ramp was just put in. It's brand new concrete. The area around the concrete there's no grass. And it appears as though that tactile is new. Mr. Loftus's clients testified that any work that's done to the road between 2009 and 2012 would have caused that area to get updated, to be put to code. Our argument is that it was never actually put to code. But again, there's no document supporting that when that tactile or ramp were installed, they were to code. And our expert says that they were not. I don't think the burden has been met to shift to us even at the start. And with regard to the Carlucci's, as pointed out by Mr. Loftus, whether or not this area is the sidewalk, isn't the sidewalk, arguments can be made on both sides of the coin, which to me is a question of fact in its own right. And Mrs. Carlucci testified she knew that this area was dangerous. She had seen the snowplows come through and rip up the grass. She didn't tell anyone. She didn't do anything. And I don't think any question the landowner has a duty to keep the sidewalk safe from any reasonable defects, which wasn't done here. And with that said, I think unless someone has a question, I'll rest.
Thank you. 7:32, Danielle Dill versus Brian S. Great, we have both of you. Could you unmute yourself, please?
Can you hear me, Your Honor?
Yes. Go ahead.
Is opposing counsel on? Okay.
Yes.
Good afternoon, and thank you, Presiding Justice Smith. Tate Riley of MHLS on behalf of BS, and may it please the court. First, my apologies. My judge, who was my mentor back in Chicago, once warned me never to get between a judge and lunch, and now I'm getting between 5 justices and their lunch. So I'll be as brief as possible. In this Rivers appeal, BS, my client, received the same primary antipsychotic, Risperdal, otherwise known as Risperidone, for 1 year prior to the hearing, and the state failed in its burden to present clear and convincing evidence that BS lacked capacity or that the medication that he received for a year was narrowly tailored to his best interests. Counsel below attempted for a short 3 pages in the record to cross-examine Dr. Das on the critical issue of treatment resistance to antipsychotics, but the lower court precluded that testimony through the objection of the state. It was preserved by the state's objection, counsel's argument, and counsel's cross-examination below. So the state's objection preserved this argument once the court precluded that further testimony, and counsel did what he was required to do under the Court of Appeals decision in People v. George, which was to call to the court's attention the purpose of the question, which was done here. Counsel below sought to explore this topic, yet the doctor provided evasive answers, and counsel made the court aware of the salience of the issue, yet the court precluded further inquiry. Attempting to explore this subject on record.
I'm sorry to do this, but this order has expired, correct? Has there been a new application that's been submitted or not?
It's almost as though Your Honor's reading my mind. So that was the next point that I wanted to turn to with mootness. Sort of as a preparatory matter, this appeal was not moot at the time parties completed their briefing in this matter. However, in the 2 months thereafter, the 1 year order has elapsed on August 23rd, 2024, and the state has not, as of last week, filed an application seeking a new treatment over objection or COPM order. Well, we make the argument, Judge, and again, this wasn't fully briefed by the parties because it wasn't moot at the time that we were briefing it. But we would make the argument this is capable of repetition yet evading review under the standard of the Court of Appeals in Hearst. We would ask this court to reach the novel issue of treatment resistance and the lower court curtailing the cross-examination on that subject. I don't believe that either party had turned to a specific case that has specifically addressed this issue, and so we would ask that this court reach that issue. This applicant specifically, or I'm sorry, this respondent, my client Brian S., actually had an appeal come up involving basically the same petition for the same medication in 2023.
Yeah, we're aware of that.
But counsel, your argument is limited to the cross-examination, isn't it? Because Dr. Das does testify this was specifically tailored to your client, and it was the least restrictive. It was the least restrictive means, and he had been on this treatment before under the prior order.
Right, and so So that's sort of our alternative argument, that if treatment resistance is not an issue in this case, then BS's significant improvement, which Dr. Doss also testified to after a year taking this medication, showed that he now had the capacity to make his own self-determination with respect to medication, and that the state had failed to show clear and convincing evidence of narrow tailoring to his best interests, specifically because of the testimony of my client with respect to the side effects that he had experienced in the year following that medication administration. And so Dr. Doss, all he basically said with respect to the continuing of the same medication that had apparently worked was that he just sort of vaguely and unspecified, had this vague and unspecified desire for a quote unquote desired effect without specifying what that desired effect was. And so it is our argument in the alternative, again, that if the treatment resistance issue is out, that BS experiencing these side effects and testifying to them competently, that the lower court did not take into account that testimony, and that it was not narrowly tailored with respect specifically to my client.
Counselor, do you know, you said that this, I had August 24th, but you said it's the 23rd. Has he been treated with this since then, or is he not being treated? Do you know what the current status is?
That is a great question, Judge. So in the record prior to, in the record, we actually see that he's taking the oral administration of the pill. Since that time, it is my understanding that he has continued to take the oral administration of the pill, and he has not been subject to the shots, although the order does allow that if he does miss a dose, then he receives the shot. And that's essentially the way it works in basically every TOO or COPM case. But as the last I knew, he was taking the oral administration of the medication.
Thank you.
Thank you.
Thank you. So we would ask, obviously, that this court either remit for further testimony on the treatment resistance issue, or alternatively, that this court reverse and vacate the order. If there are no further questions from the panel, I would otherwise rest on my brief. I appreciate your time. Thank you, judges.
Thank you.
Good afternoon, Your Honors. May it please the court, Brian Lusignan with the Office of the Attorney General, representing petitioner Dr. Danielle Dill, excuse me. The involuntary treatment order at issue in this appeal expired in August. According to my client, Brian S. has been voluntarily complying with the medication regime, and Dr. Dill therefore has not applied for a new involuntary treatment order. Because a decision on the validity of the now expired order will have no effect on Brian S.'s rights, the appeal has become moot. To the extent this court nonetheless wishes to reach the merits under the mootness exception, it should affirm for the reasons set forth in our brief, upon which I will rest unless Your Honors have questions.
Thank you very much.
Court is in recess.